Okay, so we're studying the laws of witnesses, and soon enough we got to the concept of there are two basic forms of witnesses offering testimony. The first is obviously the preferred one from the biblical perspective, is when the witnesses testify in person. That is the best possibility. But then, for practical reasons, that is not always possible, because if the witnesses testify to a transaction and then they move away or they pass away and you can't zoom them in because there was no Zoom, so then there'll be no proof. So the sages accepted the testimony through a document, which is a little bit controversial because the Torah itself says that the Talmud says that from the Torah's perspective, testimony has to be in person. A person has to be able to, the court has to hear it from the mouth of the witnesses. From a document, it's already a step away. But the sages instituted that regarding monetary law, we would accept testimony of a document. And we discussed that at length. We mentioned it a few times throughout the first 5 chapters. And now we get to the question for the next, 3 chapters, chapters 6, 7, 8. We're not going to read everything, but just to get a taste a little bit. The next 3 chapters discuss the concept of how do you authenticate a document? How do you prove that a document is real? Because if I'm a crook and I'm not saying something that is not true, so just like I'm lying about the underlying event, I could forge a document. So what's the process of authenticating a document? That is the subject of chapter 6. And chapter 6 is going to tell us that there are, in fact, 5 ways how we would authenticate a document. Most of these laws are relatively straightforward. There are some controversies in chapters 7 and 8, so hopefully we'll discuss a little bit of it when we get there. We'll go straight to Maimonides. We'll read what he says. Again, relatively straightforward. If anybody has any questions, please do not wait for the end. Please jump in and raise the question. So if you got the link, I'm reading Maimonides' Edut, which is Witnesses, chapter 6. And I'm going to read section 1. So Maimonides says as follows: as explained, the verification of the authenticity of the signatures of the witnesses to legal documents is a rabbinic provision so that the loans will be given freely. Nevertheless, we do not verify the authenticity of a legal document except in a court of 3 judges, for it is a judgment. Ordinary people, however, are acceptable to serve as the judges. For this reason, the authenticity of legal documents may not be verified at night, as we explained. So what Maimonides is getting at is as follows. The process of authenticating a document is rabbinic. In other words, it's not biblical, because from the perspective of the Torah, documents don't have any validity, at least according to Maimonides. So the rabbis say that you have to authenticate a document. So if it's only rabbinic, you would argue that it's less, the requirements of the authentication are less severe. In other words, it's less serious. But Maimonides says, nevertheless, even though it's a rabbinic obligation to accept and authenticate a document, and again, parenthetically, he says he reminds us the reason why the rabbis did so is to allow for capital to flow, for loans to be made. Because if a document is not good proof, then I'm afraid to loan money, even if there are witnesses, because I don't know if the witnesses are going to stick around. So again, to allow for the flow of money throughout the economy, we allow for the documents, which then necessitates authentication of the documents. So you would think that's rabbinic. Maimonides says no. Even though it's rabbinic, it's still considered deen. It's still considered a court case. In other words, it still has the requirements of the legal court case. And in the Torah, the legal court case has certain requirements. Number 1, it can't be done at night. So this just shows what Maimonides is trying to do is show that the rabbis consider this act of of authenticating a document has to be something that the court itself has to engage in. In other words, it has to be done just like any other court case during the day. You also need 3 people. But there is a leniency, and the leniency is that because the 3 people are here just to authenticate the document, and we'll see later the requirements, you don't have to go to law school to figure out that you recognize someone's document, someone's signature, as we will discuss. And therefore, the people the individuals who are on this court that will authenticate the document, they don't have to be experts, they can be common people. So that is the one leniency that you get regarding the concept of authenticating the document, if that makes sense. Okay, so now we're going to discuss the specific 5 ways how a document will be authenticated. And again, straightforward, quite straightforward. The authenticity of all the signatures of the witnesses to legal documents may be verified in one of 5 ways. So there are 1 in 5 ways for authenticating a document. Here we go. The first, the judges recognize the handwriting of the witnesses and know that this is so-and-so's signature and this is so-and-so's signature. This is almost a preferred way. So there's a court and the plaintiff or defendant pull out a document and the judges see the document, they see the signatures, they recognize the signatures, so they know the document is authentic, right? If we're talking about a small little shtetl, everybody knows everybody. It's not uncommon that the judge would actually know and recognize the handwriting of the witness. And then, of course, the judges could say, yes, we feel this, we know this to be a legitimate document. Why? We recognize the handwriting of the signatures. We recognize the handwriting of the signatures. In other words, we recognize the handwriting of the witnesses, so we know this is not a forgery. That's the best. Another way is good. The witnesses sign the legal document in their presence. And another authenticated document would be if in the court, 2 witnesses show up. In other words, not part of any litigation, but witnesses show up before 3 judges and they sign the document. Then the court stamps its seal of approval, and the court says this document is an authenticated document. Why? Because we saw how these witnesses signed this document. It's almost like notarizing a document, where the witnesses sign in the presence of the court. That's number 2. Number 3, C. If the witnesses who sign come and each testifies in the presence of the judges saying, this is my signature and I am a witness to this matter. Okay, so the first 2 scenarios were scenarios where the judges have firsthand knowledge. Either they recognize the handwriting of the witnesses, or they actually witnessed the witnesses signing the document. Okay. What happens if they don't? The judges, it's a big town, the judges have no idea who these signatures are, who these people are, so they don't recognize the signatures. So they have no idea whether or not this is forged. So what's the 3rd way of authenticating a document? The 3rd way is that the witnesses who actually signed the document show up in court and they testify. They say, Yankel says, this is my signature. Beryl says, this is my signature. And therefore, we have witnesses who testify that this signature is mine. So now we end up with those 2 witnesses who signed the document are back in court testifying about the authenticity of their own signatures. Okay. Now, if you have the witnesses, I don't know that you need the signatures, but that's a way of authenticating a document. Now, what happens in case number D, number 4. Here we have a case. The judges don't recognize the signatures. The witnesses who signed are gone. Either they traveled away or they died. So now, how do you authenticate a document? So these probably the last 2 are the most common. Here we go. So number D. If the witnesses to the legal document died or they were in another locale, other witnesses may come and testify to the authenticity of their signatures. Okay, so two people sign the document, two people sign, and then they move out of town, or they're not here, or we have no idea where they are. So now two other people show up and say, yes, we recognize these signatures. These signatures are authentic. They look just like the signatures of the people who are named in the document. And therefore now we testify that these signatures are authentic. So now that's the fourth way of authenticating a document. Because you have witnesses speaking and testifying and saying, we know firsthand, we know that this document is, that these signatures are authentic. And 5 is even more, is interesting. 5 is what happens if you don't have witnesses in person who could show up and say, yes, we know the witnesses, we can recognize the handwriting of these witnesses. What do you do then? That's a good question. So finally, Maimonides says, number 5, it would be, let me grab a place here. So this would be number E. If the witness's signature were found on other legal documents, the court compares these signatures to the signatures on those documents, seeing that they resemble each other, and the signatures on these documents match these signatures. So this may be the most interesting one, and of course there's going to be some interpretation of what this means and when this applies as Maimonides will proceed. But in short, what number 5 is saying, or what he calls it here number E, is saying the fifth way is I have a document. The document has two people signed. I have no idea who they are, Reuven and Shimon. I mean, we don't know the testimony. We don't know how their signature looks like. The judges don't know, and there isn't anybody to show up and say that we know that this signature belongs to these people. So what do I do then? So the fifth alternative would be to find other valid documents. How we know those valid documents are valid, we'll see later. But we find other documents that have the same signatures and we compare. So if this document in question, the signatures of this document in question is similar to the signatures on other established documents, then we could say we compare the signatures, and if they look the same, then the document in question could be authenticated. So these are our 5 ways. Okay, if anybody wants to ask a question, otherwise we continue. So let's continue to section number 3, and it's going to elaborate on the 5th point, because the 5th point is the most interesting. Again, the 5th point is a case where we have to authenticate a document. The judges don't have firsthand knowledge. They don't recognize the signatures of this document. Nobody's here. The witnesses don't show up and testify that this document is theirs, that they signed. Number 3 was, see if I remember, I don't. Number 3 was, number 2 was other witnesses. Number 2 was, again, number 1 was that the judges recognize the witnesses, the signature of the witnesses. Number 2 is the witnesses signed before the judges. The judges watched the witnesses sign and they sort of notarize it. Number 3 would be that the witnesses who sign the document show up and clarify and testify that their handwriting is on this document. That's number 3. Number 4 would be that other witnesses come and testify and say that we recognize the signatures on this document in question, and we testify that those signatures are authentic. But number 5 is if there's no witnesses that show up. No witnesses show up. So what do? You could compare the handwriting of the document of the signatures of the document in question to other well-established documents, and if those signatures match up, then we know that this document is authentic because we know the signature is authentic. How do we know the signature is authentic? Because it's the same signature that appears on other documents that are well established. So now in section 3, we have to question, so how do we know that those other documents are well established? In other words, what type of document is so powerful that it could actually allow us to use that signature to compare it to other documents that are in question? So in other words, if we have a document, we're saying if you have a well-established document, you can compare it to the document in question, and the document in question will then be authenticated based on the document that is well-established. So now we have to define what is a well-established document that will allow to use it to compare to the document in question, if that makes any sense. Okay, so that's what now we're going to learn number 3. And that will be sort of the first unit, and then we'll see what we'll do from there. So, number 3, the authenticity of the signature of the witnesses to legal documents should not be verified from documents other than. In other words, you can't just use any document to authenticate the signatures of the document in question. It has to be a well-established document. What does that mean? Here we go. So this is an example. Number 1, A, if you have 2 deeds of sale from 2 fields whose owners benefited from them for 3 years in a proper and conspicuous manner, without fear or dread from any claim in the world, as all the owners of fields benefit from their properties, or 2 ketubot. Okay, what are we saying here? Let's say I have a document in question, and I want to know if I want to authenticate this document. Who signed on this document? Reuven and Shimon, 2 individuals signed on my document that's in question. It happens to be that on my block, these 2 individuals, Reuven and Shimon, are assigned the bill of sale for 2 houses on my block. Now, those houses, the title for those houses was unquestioned. In other words, for 3 years, the owner of these houses on my block who have title, which was signed by Reuven and Shimon, those owners ate the fruit, in other words, used the field for 3 years or lived in the house for 3 years, and nobody complained. If nobody complained for 3 years, that makes us assume that the title is a legitimate title. If the title is a legitimate title, then the signature is a legitimate signature. And therefore, I can compare my unauthenticated documents to the signature on the good title. And if it looks the same, then I can authenticate my documents. So we're digging, and we're going deeper and deeper, and we're saying essentially, so ultimately what gives the authenticity is my document that's in question, we're comparing it to the document that's not in question. But why is the other document not in question? So there has to be an underlying event that allows for the authenticated document for the established document to be considered authentic. And what's underlying that is the reality on the ground. What's the reality on the ground? That other document is a document of title, a bill of sale, and that bill of sale allowed the owner of that bill of sale to eat and benefit from that piece of real estate from 3 years in a way that was uncontested. And if it was uncontested, we assume that it's legitimate, we assume that it's his, and therefore, if we know the land is his, then the bill of sale is legitimate. If the bill of sale is legitimate, then I can then compare it to the unauthenticated document and authenticate the unauthenticated document based on the bill of sale. So that is the first scenario. Let's talk about the first scenario. The reason why we say 3 years, we say the owner, if you want to establish an unauthenticated document based on an authenticated document, then the authenticated document has to be a bill of sale who the owner used that land for 3 years. So we discussed this in the past, that 3 years for real estate is a very important milestone. Once I live in the land for 3 years, then it's 3 years and it was uncontested by anybody else, then my claim to the land is much stronger. And to the extent that even if I lose my bill of sale, I will still believe that I bought the house. So all over the Talmud, there's a full tractate about this in Baba Batra, the 3rd chapter of Baba Batra, Cheskes Habatim. We discussed this in the past. All over the Talmud, if you could own real estate for 3 years, then that really says something about your claim. We assume your claim is correct. So again, the underlying power to authenticate the document is I lived in this is a home that I lived in for 3 years, and it was uncontested. I have a bill of sale. So if we assume that the home is mine because I lived in the house for 3 years, and how did I live in the house for 3 years? Based on the bill of sale, then we assume that the bill of sale is, so the action of living in the house for 3 years confers legitimacy to the bill of sale, and the bill of sale establishes the bill of sale. Now the bill of sale could be used to compare the signature on the bill of sale to the unauthenticated document, and if they match up, then the uncontested document, then the unauthenticated document will indeed be authenticated. The only thing is that I would need Maimonides says I need two, just like you need 2 witnesses to authenticate the signature, I would need 2 bills of sale to compare my unauthenticated documents, because 1 witness is not enough. We need 2 witnesses. So in this case, it's not 1 bill of sale. It's 2 bills of sale, 2 separate bills of sale that have that signature on it. So to
Rabbi,
me, what's yeah, go ahead.
I have a question about the timing. The 3 years, the people occupied for 3 years, but perhaps the owner is under duress somewhere else, imprisoned, and cannot, for some reason, get back to his legitimately owned property.
So there's a whole tractate about this.
Okay, so all right, then I won't go into that.
There are exceptions to the rule, but the general idea is that even if the owner can't get back to protest, what the owner could do is the owner could file a protest. He doesn't have to show up back in Greenwich and say somebody invaded my land, but wherever he is in the world, or wherever she is in the world, he has to say somebody is in my land illegitimately, and I am going to contest that in court when I have the opportunity to. So if you did that, if you're the original owner and someone invades your land and you can't stop what you're doing and show up in Greenwich because you're living in Australia, you can actually, or you don't actually have to show up, but you have to lodge a protest. Now, if you're in prison, you can't lodge a protest. That's the exception, and that exception will be taken into account. But we're talking about a straightforward case. There's an original owner. The original owner sells the land. There's a bill of sale. The buyer is living in the land for 3 years, uncontested. That makes us assume that he is the owner of the land, and that makes us assume that the bill of sale is legitimate, and therefore we can use the bill of sale to compare it to the unauthenticated document. And if the signatures line up, we'll authenticate the document in question based on the bill of sale, which we take to be established, to be correct and established. Why do we consider it established? Because in the real world, this bill of sale this document had an effect. What was the effect? It allowed the buyer to benefit from the land for 3 years. So what I like about this idea is we're not just comparing documents, but we're going deeper and deeper. We're saying we're comparing the document in question to an established document, but then we ask who said that established document itself is proper. So then we have to go deeper, and then when we get to is what's proof about the underlying proof is the real world. The underlying proof is the fact that the person owned the real estate and used the real estate for 3 years. That real world experience confers authenticity to the document, which then allows us to use that document to help the document in question. In other words, in the beginning, when you look at it, you think that the documents create the ownership. the documents prove the ownership. That's in the beginning. But over time, the ownership, the fact that the person lives in the land is actually what authenticates his documents and then allows that document to be used to authenticate other documents. So it's interesting to contemplate what is the underlying question, what is the underlying legitimacy of any documents. And in some sense, it's the real world experience. So that was one example. The other example that you could use is not real estate, but a ketubah, a marriage contract. So if I have a document that we're trying to authenticate and two people signed it, Reuven and Shimon, I happen to know that those two people signed two marriage contracts. If I can produce those two marriage contracts, then we could use the marriage contracts to authenticate the document in question. Who told you the marriage contracts are authentic? Well, who told you? The marriage told you, right? So again, we're looking at the real world. The real world is there is a marriage, and the marriage is continuing based on the marriage contract, because the marriage contract, the ketubah, is very interesting. It's not just like your marriage license. According to Judaism, the ketubah is the document that protects the woman's right within the marriage. So in other words, if the husband dies or divorces his wife, the ketubah says that he has to give a certain amount of money to his wife. Why did the sages institute a ketubah? So the Talmud says we want to make sure that a person will think twice before he divorces his wife. How do you make a man think twice before he divorces his wife? You make him pay. It worked then, it works now. So divorce is allowed, but there has to be a consequence. In other words, you can't just do it frivolously. You have to do it when you're serious. And therefore we say a person must have the ketubah in order to be married. Now the sages go further. What happens if the woman loses her ketubah? She lost it. If the woman loses her ketubah, says the Talmud, they're not allowed to remain together in the same home until they write a new one. Because we don't want this marriage at any point to be a marriage where the woman is not financially protected. And therefore, every moment that this couple is living in the same home, they're doing so because of the authenticity of the ketubah. So again, what testifies to the fact that this ketubah is correct, is accurate? The fact that they're living together. So the marriage itself testifies to the fact that the ketubah is authentic. And if the ketubah is authentic, then we could use the ketubah to establish the document in question. So it's either two separate documents of real estate, but not just any real estate whose owner, who the buyer, the bill of sale, and the owner and the buyer, based on this bill of sale, lived and used this field or this land or this home for 3 years, and it was uncontested. That would authenticate that bill of sale. Or I can produce two ketubot, two marriage documents that have these witnesses sign on those marriage documents, and then compare it to the document in question. This is the clarification of the fifth point. If you're going to authenticate a document by comparing it to other documents, then you would have to use documents of real estate or documents of ketubah. So because this is going so well and everyone behaves so well, I'm going to take a 60-second break because I have to just help out here for a moment, and I'll be back in 30 or 45 seconds. I apologize for the inconvenience. Oops, sorry for that, back in the game. Okay.
Rabbi, there's always two documents, one to confirm the other in any transaction, or is it just in real estate and marriage?
No, there are other documents that need to be, all documents need to be confirmed. If I have a document that says, if you produce a document that says I owe you $50, and I question the authenticity of the document, I say, I'm sorry, with all due respect, it's a forgery. So now we have to, Jill, now you have to authenticate your documents. So you have to say, you have to prove that those signatures are legitimate. How do you do so? So there are 5 ways to do so. The 5th way is if you get other documents that have the same signatures, that would imply, and those documents are considered legitimate, then your document is legitimate too. But then the question becomes, how do we know that those other documents that you're producing are legitimate? So just having a document is not enough. What the Maimonides is saying, we need real world experience. We need facts on the ground. We need reality, actual reality that will then say that those documents that you're bringing to prove that your document is legitimate is indeed legitimate. So what documents do we know for sure are true? So we know marriage and we know the bill of sale. But any other document, it could be that the document you're bringing is also forged. So for example, if you're trying to prove that I owe you $50 and you produce a document that says I owe you $50, and then there are 2 other documents that say that someone owes someone $50 with those same signatures of those same witnesses, how do you then know that those documents themselves are legitimate? So in other words, ultimately, we have to get to a concrete fact that tells us that the document is authentic. So Maimonides says the 2 concrete facts is when there's a document that allows for someone to live on the land, that's real. That's why they call it real estate. That's real. And of course, marriage is also real. And therefore, those are the examples that it's not just having a document, but you can prove that the document that you're trying to use to authenticate the document actually had a real world effect.
Thank you.
I think that's what's taking place here. Okay, we have one more thing we have to clarify here. So we're in the second paragraph, I guess the 3rd paragraph in section 3. These 2 legal documents must be in the possession of another person and not in the possession of the person who seeks to validate his legal documents. Or it is possible he forged all the signatures. So what happens if I produce a document? It's a document is in question, and I have to authenticate the document that I produced. So I say, well, you know what? I've got 2 bills of sale that testify that to 2 sales, and look, those sales have been uncontested. That won't do it. Why won't that do it? Because I'm the one who's trying to authenticate my own document, and I produced that bill of sale. It's not enough for me to produce that bill of sale, because it could be I forged my document, the document that I want to get authenticated, and I also forged the other 2 documents. I forged a document that says that Jill bought her house, right? So the fact that I have the bill of sale, that doesn't mean anything. So that doesn't mean I didn't forge it. Therefore, what we're saying is those other documents that are produced that prove the authenticity of my document have to be documents that were in the possession of other people, not in my own possession. If they were in my own possession, then then we don't believe that. If it's in my own possession, then we don't believe that. Then there's no proof, right? So if I produce a document that says that somebody owes me $50, and then they say, well, we're not sure about the documents. We're not sure about the signatures. So I say, well, I got 2 bills of sale. One bill of sale, I have a copy of it, says that Jill bought her house in whatever year. And the other bill of sale says that someone else bought his house all those years ago. And I happen to have a copy of both bills of sale. We say, we don't trust you. I know Jill lives in her house, but I don't trust you that this bill of sale is indeed the original bill of sale. Maybe this is a forgery. So again, that's why Maimonides clarifies that if you're going to prove if you're going to prove based on the authenticity of your document, based on other documents that, again, are backed up by reality on the ground by the person living in the house for all those years, then who has to have those documents in possession? Somebody else has to have those documents in their possession. If the person trying to authenticate his own document produces those other documents, then that is not a legitimate source of proving the authenticity, because it's possible, as we mentioned, it's possible that they were all forged together. Now we have one more case, one more way to authenticate a document based on other documents. And so the first case was a real estate sale, 2 real estate sales. The other one was comparing it to signatures on a marriage contract. And the third would be comparing it to a document whose authenticity was challenged in court, and the court validated and authenticated the document because they went and they found that that document is correct. So the third way is if there was a document that was challenged in court and then validated in the court, and the court approved of this document, then you know that those signatures are legitimate. And if this document in question's signatures compared to those signatures, then we could authenticate both documents. Then we can authenticate the document in question. So we'll continue to read at the end of section 3 in Maimonides. Similarly, we may validate a legal document by comparing the signatures of the witnesses to those in a legal document whose authenticity was challenged and then verified by a court of law. Such a legal document alone can be used to verify the authenticity of the signatures to a legal document, just as a legal document can be validated by comparing it to deeds of sale with 2 fields or 2 ketubot. So that is the first part of chapter number 6. There are another few laws at the end. I think maybe we'll go to chapter 7. If you have the link on Chabad.org, you just hit next on top of the page, and we'll just do a few more short laws. We'll try to end on time. That's in 6 minutes, but we want to just read a little bit more. This may be a little lighter, maybe easier. Here we go. Again, the principle is that we're talking about the authenticating documents, which is a rabbinic business, because in the Torah, the whole concept of documents doesn't apply. So it's rabbinic. So if it's rabbinic, the rabbis are more lenient. Where are they more lenient? Here is a very interesting law. In general, according to the Torah, a relative is disqualified to be a witness for any matter regarding any relative. So how do you define relative is another question, but let's assume that this is what the halacha calls a karov, a relative. If I am a relative, I am disqualified to testify for the good or for the bad against my relative. There is an exception. What's the exception? The exception is I could testify that I recognize the signature of my relative in order to authenticate the document upon which my relative has signed. Why? You say, what do you mean? Don't we know the law of the Torah that we don't accept the signature, the testimony of relatives? Well, because the rabbis were the ones who require the authenticity, so they could be lenient and they could say, we're loosening the rules for authenticating documents, and we will accept the testimony of relatives. Again, the whole purpose of documents is to make it easier for people to borrow money and lend money and collect money and collect the debt through the documents. So if you're going to make it too difficult to authenticate a document, then there'll be no more loans. If there'll be no more loans, there'll be no more economy. So again, the rabbis have to make it easier for people to take loans, and therefore easier to write documents, and therefore easier to authenticate documents. And therefore they allow for the relatives signing. I also think, I may be wrong, that it's most likely who would know the signature of the document, who would recognize the signature of somebody else? Typically, the relatives are the ones who actually recognize the signature. Look, I know who you are. You're on this call. I know who you are. Do I know what your signature looks like? Not necessarily. But your child or your spouse or your parent actually may actually recognize your signature. So it's possible that the reason why the rabbis allow for the signature of the relatives is because it's most common that they would actually know and recognize the signature. That's my idea. Maybe right, maybe wrong. I don't know. But in any case, again, we're not talking about relatives testifying about the loan. That would be unacceptable. We're talking about relatives, not of the main parties, not of the plaintiff and the defendants. No, we're talking about relatives of the witnesses who testify that they recognize the signature of their relatives. So these relatives are testifying to the signature of and establishing the witnesses, but they're not relatives to the actual parties of the case. If they would be relatives to the actual parties of the case, their testimony would be rejected according to the Torah law. But because they're just testifying to the authenticity of this document, which is a rabbinic process, so the rabbis lifted this requirement and say, look, if you relate it to the witness, you can testify that this is your relative. So we'll read section 1 of chapter 7, and we'll see from there. A relative may give testimony with regard to his relative's signature. And again, like I said, this is a big idea because typically we do not allow for the testimony of relatives. What is implied? There are 2 legal documents which Reuven and Shimon signed as witnesses. They died or traveled overseas. Reuven's son comes and testifies, this is my father's signature. And Shimon's son came and testified, this is my father's signature. It is as if they are 2 acceptable witnesses who are not related to the witnesses who have signed. If a third witness joins together with them and testifies with regard to the 2 signatures, the authenticity of the legal document is validated. The thing here is you need 2 witnesses to authenticate each signature. So Reuven and Shimon are the witnesses of this document. They both die or they're out of town. Reuven's son shows up and says, this is my father's signature. Shimon's son shows up and says, this is my father's signature. It's wonderful. We have 1 witness for each signature. We're going to need a second witness. And therefore, if a third person comes to town and says, I recognize both these signatures, then the document is authenticated. So again, the big idea in section 1 is that the rabbis are lenient and they allow for relatives to authenticate the signature of their relatives. And in section 2, which we won't read inside, I'll just mention it by heart. In section 2 is another leniency. Typically, a child cannot testify, and typically an adult can testify regarding what he saw as a child. But with regard to establishing witnesses, to establishing the document, an adult could show up and say, when I was a child, I hung out in this person's house and I recognize his signature. That is a document that is a testimony that would not be accepted regarding a biblical matter, but because this is a rabbinic matter, the document is accepted. So again, these are cases, these are examples. We're trying to have a balance here. We're trying to protect everybody's rights. On one hand, we're trying to protect the defendant. And if you produce a document, we're going to question it and say, hey, maybe a document is forged. We have to establish the authenticity of the document. We're just not just going to accept it on face value. That's on one hand. On the other hand, there are certain leniencies that allow us to accept witnesses that we would not accept in normal circumstances. We will allow that the Torah, the Talmud, the rabbinic law would allow us to accept those witnesses regarding the establishment of the authenticating of the document, because we don't want to make it too hard to authenticate the document, because then the result would be we make it too hard to collect the loan, and that would mean nobody will make any loans, and then we'll be in big trouble. So that's the story in short. A little technical today. I hope it's somewhat interesting. We will continue Maimonides, the laws of witnesses, next Tuesday. And other than that, we have a class tomorrow, Song of Songs. We have Thursday, the Parsha, Friday, Hasidic philosophy. So looking forward to seeing everybody in good health. If anybody has any questions, now would be a wonderful time. Otherwise, have a wonderful day. Enjoy the day.
Rabbi, it's the same question I think I ask each time, but why do we study this in such detail if it doesn't have application to today's law?
So there are a few reasons. First of all, we believe that this is the divine wisdom. So there's a mitzvah of studying the divine wisdom. So the divine wisdom, I'll have to connect to you. Let's say I have to connect to you, Jill. So there are all kinds of ways of connecting. One way of connecting is if I could see the world through your glasses, if I could see the world through your perspective. So if we're studying the divine wisdom, we are actually getting a taste of how God looks at the world. So that in itself is a spiritual activity. It's a holy activity. It's the mitzvah of studying Torah. That's point one. Point number two, discussing these issues, even though you or me are not going to be a judge, and we don't expect to be a judge or a lawyer, but it is an important discussion because what it trains us to do, it trains us to ask questions and apply it to our life, even if we're not applying the actual case, but it's training us how to think about a scenario and weigh both possibilities. So when someone comes and tells me something, what did today's practice tell us? Today's practice tells us that we have two competing interests, and we have to figure out how to walk a fine line and balance both interests. In other words, we have to question the documents and demand some authenticity. On the other hand, we can't make it too difficult. Imagine somebody says, I don't believe it until you prove it. Okay. On the other hand, someone says, I don't believe anything until you prove it to me conclusively with 100% certainty, right? Either of those paths are not going to allow you to live your life, because you're not going to be able to buy anything on Amazon because you're not going to trust any of the testimony of the reviewers. In other words, life is about looking at balancing the various perspectives. And this is what we did today. And if you do it regarding documents, then you also learn how to do it in your own life. You look at a scenario and you say, what are the interests here? What are the competing interests? And how do I carve out a path that would at least address both of those interests? Sort of the middle path, where on one hand, for example, I want clarity, I want to prove, I want evidence, I want to be able to be certain that this document is true. I want to protect the defendant. I want to protect the defendant who is being asked to pay back the loan. On the other hand, we don't want to make it too difficult because we want to protect the lender, the one giving the money, because if we don't, there'll be no more loans. So this is an activity that even in a practical sense will have an impact in your life, because it teaches you and it teaches us to look at any scenario, identify who are the parties, identify what are the competing interests, and then work. We don't always get it right, but work to try to carve a path that would at least address the main concerns of both those parties. If I can do this in all areas of my life, I will live a better life.
Thank you, Rabbi.
Thank
Good
you,
answer.
Jill. Thank you. But it is a fascinating concept that in Torah and Judaism, everybody, so that's the second answer. I'll give you a third answer. The third answer is that what is law? Law is our values. And the fact that we live in a country, or in general in the West, that the law is practiced, written, practiced, and interpreted and understood by only a very small slice of the population is a terrible thing, because people are affected by the law and people should know the law, because the law is how society presents it, shapes its values. So the fact that we outsource the understanding of the law and the application of the law to a certain profession, I think is a bad thing. And in the Torah, you would have, in Jewish culture, you would have people who would never be a lawyer, never be a judge. They could be a doctor, they could be an accountant, or they could be a farmer. Whatever they're going to do when they get home, they open the Talmud and start talking about the law. because law is basically right and wrong. How do we get clarity in a complicated world? And the fact that in the West, it's only given to a small segment of the population, in my mind, is a terrible thing, a terrible waste. Everybody should be thinking about the law and debating the law, regardless of what you're doing as your main profession or your main vocation. So that's 3 answers. Look at that.
Thank you, Rabbi.
Okay.
You had reference to the divinity of it. I just thought that divinity of the law really just came from Hashem and from the Torah, and that the rabbinical, you were referring to rabbinical.
So I mentioned, number one, I said, you're right. Number one, I said that this is the mitzvah of studying the divine wisdom. The problem is, as you correctly identify, that we're not really studying the divine wisdom. We're studying human wisdom, because this is not the law of the Torah per se. This is the rabbis interpreting the laws of the Torah. And in fact, in this case, they're actually stepping away from the laws of the Torah, right? Because the laws of the Torah say that you need actual witnesses. And here, the whole entire discussion is about documents which the rabbis say is okay. So are we indeed studying divine law, or are we studying human law? So the answer is that according to the tradition, the whole beauty of the Torah is that we are discussing, it's a combination of the divine law and human law. In other words, divine input and human input. And when the rabbis, even when they're offering their own logic, they're doing it based on the principles and based on the enlightenment that the Torah gives you. So we are studying the divine law, the way it comes through is filtered through the perspective of people. And that's the ultimate goal. That's what we want. That's what God wants. So it still is the divine law. Now we'll elaborate upon that on Thursday when we discuss the Parsha, because that's sort of the theme of the book of Deuteronomy, which is Moshe formulating the divine ideas in his own words. And the sages explain that's a metaphor for the oral Torah, where of course the sages and the rabbis are coming up with the ideas, but they're doing it based on the input of a divine perspective. So the answer is, you're right. It's not 100% divine law. It's what the Torah sees as the marriage of the divine perspective and the human perspective, and the combination. So by extension, it is the divine law. It's the way the divine law is applied by the sages. In other words, what would the Torah want us to do in a scenario where, if we're too strict, there would be no loans? Well, we know the Torah is all for loans. We know the Torah says it's a mitzvah to give loans, and it's a negative prohibition to refrain from giving loans just because you're afraid you're not going to get paid back. So we know what the Torah is very much pro loans. So now what would the Torah say in a scenario where being too strict would not allow for the collecting of loans, which then would not allow for the giving of loans? So this is where the human input comes in, based on the divine ideas. What would the Torah say in this scenario? So by extension, it is really the divine wisdom. It's the divine wisdom as filtered through the human consciousness. And that's really the marriage of Torah, it is about the partnership of people and God. So that's part of the beauty.
Thank you.
Okay, look, you got a little philosophy at the end. It's not just law. Okay, everyone have a wonderful day. It's been a pleasure spending time with you, as always. Hope to see you soon in good health.
See you tomorrow.
Be well.
Bye.